Closed captioning for Justice and Law Weekly is provided in part by the Clifford Law Offices in support of quality public television for the Chicago area.
Welcome to Justice and Law Weekly, sponsored by the Chicago Bar Association. I'm Aurora Balastriaco, president of the Chicago Bar Association. The Cook County Public Guardian Office employs over 260 people, including 130 lawyers. It is the only law office of its kind in the country that combines the legal representation of abused and neglected children, children in custody divorce cases, and disabled elderly wards. On December 1st, 2004, Robert F. Harris became the Cook County Public Guardian. Mr. Harris has long been an advocate for children and the elderly. Prior to becoming a lawyer, Mr. Harris was an engineer. Welcome, Mr. Harris.
Thank you, Aurora. I appreciate being here.
And thank you so much, because I know your schedule is very full, and for you to be here is greatly appreciated.
Yeah, and it's such a beautiful day, too.
Right. Let me ask you the first question, which I think is the question that most people ask. Is the public guardian appointed?
Yes, I was appointed by the Chief Judge of the Circuit Court of Cook County, and Cook County is a little different than I think most of the counties in the state, because many of the other public guardians are appointed by the governor. But in counties of 1 million or more people, then the Chief Judge, whoever the Chief Judge is, appoints.
Right. Now, there are 3 divisions in the public guardian's office. What are those divisions?
The largest division, with about 6,000 clients, is the Juvenile division. The next largest division is the Adult Guardianship division, and then we have a practice in the Divorce and Custody courts. That's the Domestic Relations division.
Right. Now, in the Juvenile division, let's talk about that. What is the difference between an attorney and a guardian ad litem?
Okay. So we're actually appointed both in the Juvenile division in most cases. And so the statute of the Juvenile Court Act requires that a guardian ad litem be appointed upon the filing of the petition. So, and the child is entitled to a lawyer. And so at the outset, at the very first thing, one of the first things the judges do is to appoint a lawyer and a guardian ad litem for the child. And generally in Cook County, that's us.
Right. Now, are children and youth allowed to come to court and view what's going on with the hearings?
Yes. In fact, it's encouraged that they come, unless it's something detrimental to the children, then generally they'll come to court. And I don't know if I answered your first question thoroughly enough, but the guardian ad litem really speaks to what's best for the child, the best interest of the child. And then the attorney does what attorneys do, and they advocate for the child and often for their best interest. As a GAL, you don't have to be a lawyer, and if you're not a lawyer, then a lawyer can be appointed for you. In our case, that we're rolled into one, acting as lawyer and guardian ad litem. Right.
Does the child representative interview the child, or does the child interview who the guardian ad litem?
Well, we act as the child representative in the domestic relations and the custody courts. And the child representative is appointed generally if there's something really contested going on with respect to custody and visitation in a domestic relations case. And so in most cases, you won't necessarily see a child representative. You'll only see them if the parents can't get their acts together to agree to something. And then the judge, or on the motion of one of the parties, one of the parents, will appoint a child representative. And that person then interviews the child, interviews the parents, and then actively advocates for what's best for the child.
Right. So how much weight does the court give to a child representative?
I think there's a great deal of deference that's given to child representatives from the perspective that they aren't swept up in often what would be the emotion of a particular case. They're only appointed when the parents can't come to some agreement. And so the court is looking to somebody else to help them hear what the evidence is in terms of what whether a child should be placed with one parent or the other, or what kind of visitation the child should have.
Right.
So really we're acting kind of, as a stopgap for the judges. I
Right,
think.
and you report then, the child representative would report to the court orally and in written report?
Actually, we try not to report because we don't want, as a child representative, what what you're allowed to have. You have the powers of a guardian ad litem, but you have the tools of a lawyer. So you're acting as a lawyer, and so what we try to stay away from is just doing a recommendation. So what we'll do is present evidence and present the position that we formed based on the evidence adduced from talking to the parents, talking to the child, talking to teachers, talking to all kinds of folks, and the evidence that both the parents will put on as well.
Right. Do you have the children as witnesses? Do you have them testify?
In general, no. And particularly in divorce and custody cases, because you really don't want to pit a child in the middle of their parents. And so we really try to avoid that if at all possible. Some children do want to testify and want to express to the court what they want, and so we'll certainly present that picture. In juvenile cases, on the other hand, often the children don't have to testify. Findings can be made if there's corroborative. You can use an out-of-court statement of a child with respect to physical abuse or sexual abuse, if there's corroborative evidence, and that evidence is usually derived from specific medical reports, doctor's reports, or psychiatrists or psychologist reports as well that corroborate what they've said. In the juvenile court, it's a bit different. Sometimes it's cathartic for the children to testify. Sometimes they really want to testify about a particular thing, not just at trial when you're trying to adduce whether or not there was actual abuse or neglect, but also they'll want to testify about visits, about a particular home that they lived in or want to live in, or about whether their cases should be closed, or about whether what the goal is in a case, whether it's adoption or guardianship or return home in a particular case.
Right. Do you even go as far as visiting the child at their home just to see the conditions?
Oh yeah, especially in the juvenile court. We're mandated as guardian ad litems to go out and see children at least once a year, our clients once a year. We see them often much more than that, and we'll do it in a number of ways. Either the lawyer that's assigned will go out and see the child, interview the child in the home, or they'll come into the office depending on what the issues are. Or we also work with caseworkers and utilize them. We call them child interviewers. They go out and are skilled, and most of them have worked in the child welfare industry for a number of years. Some have LCSWs, some have other MSWs, and they'll go out and interview our clients as well and help us to advocate for them. So I think one of the critical things for our office is to have an idea of what particularly in the juvenile division, is to have an idea of what the circumstances are. See where they live, get to know who our clients are, and in order to be able to advocate for such a personal thing as family and visits and adoption and return home and that kind of stuff.
Right.
Most often, I think in the in the domestic relations cases, the children come into the office, kind of a neutral setting. They might come in with one or the other parent, but it's kind of a neutral setting, and you're not, in one parent's home or the other parent's home, or in a home that might be really tense at the time. So it gives them an opportunity to relax and just to talk freely.
Right. Now, is the juvenile division the largest division of the three?
Oh yeah, it's we have 6,000 clients. We have about 800 clients in each the adult and also in the domestic relations divisions. So a lot of our clients do come out of the juvenile division.
Right. Now, you mentioned the adult guardianship that you have, which is actually the third division
Yes.
that you have, and that's working primarily with the elderly and the disabled.
Yes.
Now, how would the public guardian's office become involved in a situation like that?
In a number of ways. So we get calls from people in the community to come out, investigate a case. We get referrals from the elder abuse agencies. We've had judges call us over when a litigant is presenting in a way in which they think that they might need help, might need guardianship, and so we'll come over and and do an evaluation or set up an evaluation. Banks call us, police officers, neighbors, relatives, all kinds of folks call. And what we'll do is we'll open it for an intake, and so we'll have our own internal people maybe go out and assess the situation. Get the intake people will get a lot of information, find out where the ward lives. We'll send someone out from the office. We'll also, we contract with some psychiatrists because in order to obtain a guardianship, as you know, Aurora, this is your expertise,
Right.
you have to have a medical report, a CCP 211, that accompanies the petition for guardianship, and that outlines whether or not a person is disabled as to their person or whether they're disabled as to their estate or both, one or the other or both. So.
Right. No, it's actually very interesting, and I know we've had some kids, as a matter of fact, that we've worked on. Now, does the Cook County Public Guardian charge fees for services?
We do charge fees. Largely, we don't charge fees in the juvenile division unless we do money damages suits against a particular private agencies or other entities, and we might ask for fees for our legal work in that respect. But in general, in the juvenile division, we don't. But in the domestic relations and in the adult guardianship divisions, yes, we are entitled to bill for fees for the work that we do. It's a way in which to recompense the people of Cook County, the taxpayers of Cook County, and the statute allows for it. Of course, our fees are not anywhere near what private lawyers might charge or private agencies might charge to do some of the guardianship work as well, but they're fees nonetheless. And over the last 8 years since I've been appointed, we have recognized that that's a way in which the county, to avoid large cuts from the county, is to be a revenue generating entity. And so we've more than doubled our fees at least last year from when I first took over in 2004.
Right. Now, there are situations where there's a fraud that's going on against an elderly person. So you go in there and you get appointed.
Yes.
And then also you do work with a Cook County State's Attorney as well.
Yeah.
Can you tell us and explain to us how that relationship works?
Well, what will happen is many of the cases, not all, but many of the cases that we are referred to, there's some element of exploitation of the elderly person, whether it's someone's come in and put their name on their home, put their names on their bank accounts, written out a will on a person that's clearly disabled with Alzheimer's or dementia, naming them as the heir to everything that these people have worked so hard for all of their lives. And so we'll come in, and under the Probate Act, there's a section that allows for citations to be filed, citations to recover assets that have been stolen from our wards. Discover and then recover assets stolen from our wards. And so we have a very strong unit called the Financial Recovery Unit, FRU, as they say in the office. And over the past several years, I'd say the past 10 years, we've recovered, about, let me get my numbers correct, I think about $60 million right now, I'd say. And that's through all kinds of things. That's from simple things like getting their houses returned to them, to recovering monies that have been stolen from them. Tens and hundreds of thousands of dollars have been stolen from people. And in some of the cases that we've had, we have referred the matter to the state's attorney's office. I think when I first took over, there were probably fewer elderly exploitation criminal cases, and I think over the last few years I've been pleased to see that there have been much more activity in terms of charging and actual convictions of people for stealing and exploiting the elderly. And not only do we work with the Cook County State's Attorney's Office, but we've worked with the U.S. Attorney's Office. We had a case in which a woman was exploited of about $300,000 by a bank teller. This woman styled herself as our client's personal, our ward's personal banker in a very large financial institution. And we learned about it actually from the financial institution, and we referred the case to the U.S. Attorney's Office and to the FBI, I believe, also obviously assisted first. And then they ultimately received a conviction, which was a really unheard of thing. I don't think we had we had a federal case.
I don't think, yeah.
And that was very early on in my tenure, I think in 2005. And that's, it's not always great to see people go to jail, but it is great to see people who are taken out of service, so to speak, who rip off the elderly, because you can't think of anybody worse than somebody that would just rob someone of their life savings like that.
Right, and not only that, but we've got a huge population explosion of senior citizens in the next 25 years. So I would imagine you'll probably see a lot more of the financial exploitation cases.
I certainly will. I'm sure our office will. Maybe I won't be around, and hopefully I won't want to be one of the exploiters, because I'm a baby boomer as well. But I hope, and I think that the country is becoming more in tune with this aspect of exploitation. I know that one of your guests that you like to have on is the Chief Judge, Timothy Evans, the man that appointed me, and the presiding judge, Patricia Banks,
right,
who is the presiding judge for the Elder Law and Miscellaneous Remedies Division. And I know that would be an important thing, I think, for people to see. And I know that that's something you're working on. And I think that's in recognition of the coming wave of the elderly as we all get older, and as we see more need to pay more attention to what's going on and how the justice system really reacts and not caters to, but handles cases of the elderly.
Right.
The sensitivity that sometimes you need to have when you're dealing with people who are a little older, a little slower.
Right. No, you're absolutely. And we're forever going to be young, right?
Well, we often hope so, but sadly, I don't know that always happens.
Right. Now, when the public guardian collects money for a disabled, does the government take a percentage of that money, or does the government take all of that money,
no.
Do they give it back to
What
the victims?
happens is, if we recover money for our wards, that money is actually put into a bank account or an investment account that is for them, and so we use their money to essentially take care of them in this part of their lives when they're unable to take care of themselves. I wanted to add, in terms of my appointment and cases that we see, I really believe, and that's the philosophy of the office. Sometimes the judges don't see it that way, but that we're guardian of last resort. And so if there's a better person, someone more personal, either a family member or a good friend that is ready and able and willing to act as guardian, I think those people are the people that should, the entities that should take over and act as guardian. So, having said that, no, the government doesn't take their money. It's still their money, right. But we do manage it, and I have fiduciary responsibilities about how to manage it, and so we try to act accordingly.
Right. Now, what is the difference between the Office of the Public Guardian, Office of the State Guardian, OPG and OSG?
Yes, OPG and OSG. The threshold of the amount of the estate is one of the big differences between the office. So my office is appointed on estates of at least $25,000 or more, and OSG is appointed on estates of less than $25,000. And so largely what you'll see is my my wards will have amassed something. And, it used to be that, $25,000 meant a garage, and now we're seeing houses not worth as much as they used to be. So, if you've got $25,000, whether it's equity in your home or whether you have it in a bank account, then you would have the opportunity to be appointed under the auspices of my office. Another difference, I think, statutorily is I think we have, obviously, because of the estate, but there are other fiduciary duties that we have responsibility for, and so you'll see us managing investment accounts or hiring or contracting with someone to manage an investment account, reporting to the court annually about the estate and our comings and goings with the use of the money for the estate. Also, the statute requires that I minimally see my wards once a month. Not me personally, but someone from my office, although I love going out and seeing the wards. But as you can imagine, it's difficult to see all of them. But we minimally see our wards once a month. And actually, it really depends on what's going on in the case, and we'll see them a lot more than that. Now, people get a little afraid when we say we see them once a month. So you might have this sweet old lady who's living in the community, who's got Alzheimer's and really isn't able to care for herself. Well, we really utilize other people. We have a home care department, which is pretty unique in the country, I think, in which we contract with individuals, CNAs and other types to spend from 12 hours, 4 hours to 24 hours a day taking care of our wards. And so there's a lot of more eyes and ears than just once a month on our wards, I promise you.
Right. Well, now that you mentioned about that, how about the disabled adults? Do you place them in nursing homes? Do you have that power if there's nobody else who's able to care for them?
We do have the authority to place in nursing homes after we've, really seen the nursing home and vetted it as an appropriate place. But one of our favorite charges is to maintain them in the community, to allow people to have as much independence as they possibly can, even given the circumstances of acting under a guardianship. And so we still have about a third of our wards that are in the community in various, in their own homes, and pooling resources with other wards, but certainly people who are able we can maintain safely in the community. So we really try to keep them in the community if at all possible.
Yeah, which I think is really important for stability for that person.
Absolutely.
But if there are family members, why would the public guardian be appointed, a guardian for that person? Unless the family member refuses, correct?
Unless the family member refuses. But sometimes there are family members that are also exploiters as well. Or sometimes there are family members who just aren't able to take care of their elderly parent, for all kinds of reasons, from living out of state or just physically not being able to do it and having other demands. And so we'll be appointed in those cases when there isn't anyone that's appropriate or available to take care of them. Sometimes the judges try to appoint us when there are really able-bodied people to do it, and we really try to stay out of that. We really, if we can offer some assistance to the court and by way of information, we'll do that. But we really would prefer a person to be taken care of by the person that knows them the best.
Right. Now, the elderly and disabled are a particularly vulnerable group. I mean, we both know that, especially to financial exploitation. I understand you have set up you mentioned the financial recovery unit.
Yes.
And have recovered more than $33 million over the past.
Actually, more than that. I think that's one of the old numbers.
So we were talking about $60 million. You just mentioned that number.
It's a lot more. We've gone up. We've recovered a lot of money.
Can you tell us some of the scams that you have out there where you've actually recovered the money?
Okay. Or property, too.
Or
a
properties,
lot of it is also houses. Well, the one I talked about was the personal banker who was actually siphoning money off from her account. She thought that, she befriended her. This woman would go into the main branch of this particular bank and had been doing so all of her life, had always banked there. And she just befriended her, would have her sign checks claiming she was going to pay certain bills. She was actually paying tuition for her child, I believe, and all kinds of things. We've had another major case that we've had was a gentleman who was the head of the largest not-for-profit in the state, was receiving a lot of monies from the feds, who was exploiting his longtime secretary. Again, just became power of attorney and started taking money from her, or having her sign checks for just all kinds of money for whatever reason, and stole, I think, about $70,000 from her. We've had people who've committed mortgage fraud. We'll have people come in and say, hey, let me help you with this loan. It'll, because we want to make sure that the government doesn't take your house. So the mortgage fraud has been a big thing that we've been dealing with. We've had police officers that, one big case that we had was a police officer who met a gentleman who was suffering from Alzheimer's when he was responding to a call that this gentleman was in the neighbor's home. So he came out, the neighbor called the police, he came out, befriended this gentleman, then proceeded to put his name on his bank accounts, develop a will so that he would leave all of his property to him, that kind of stuff. And we've had other cases similar, with other police officers. I have to say, by and large, the police, when they find out that it's one of their own, they are the best people to have on your side, because obviously that's not what they stand for, and that's not what they do in general, and they've been very helpful to us, I have to say. But there have been police officers, people for Meals on Wheels, the contractor scammers, all kinds of scams.
Right.
You wouldn't believe it.
Right. Well, we're out of time, and I'd like to actually thank you for coming. It's been very, very informative. And Mr. Harris, thank you so much for educating us about the important work of the Cook County Public Guardian. I'm Aurora Balastriaco. Thank you for watching Justice and Law Weekly.
Closed captioning for Justice and Law Weekly is provided in part by the Clifford Law Offices in support of quality public television for the Chicago area.